related to controlled substances. This bill increases the penalty for knowing possession of a controlled substance or counterfeit substance to a gross misdemeanor. It creates a pretrial diversion program for individuals charged with possession. It provides for vacating possession convictions contingent on the individual completing a substance use disorder treatment, and it creates and funds several substance use disorder initiatives. There is a table in your EBB summarizing the estimated local and state impacts of this bill. This is the same table that you got in committee follow-up via email yesterday. It also contains information on the appropriations contained in the substitute bill. At a high level, the fiscal note in your EBB indicates local costs for additional court hearings and diversion, state costs for treatment, expansion, and administration, and general fund state appropriations of $44 million over the 23-25 biennium for medications for opioid use disorder in jail programs, clubhouse programs, and 23-hour crisis facilities. The first amendment on 5536 is a proposed substitute, Amendment C in your packets, offered by Senator Robinson. This substitute does several things. It exempts public health and syringe service programs from criminal liability. It declares that nothing prevents defense attorneys from seeking to resolve drug possession charges through a therapeutic court instead of the pretrial diversion program created in the bill. It requires that courts assist defendants participating in the pretrial diversion program with obtaining a substance use disorder evaluation within 7 days. And it requires the evaluation to be provided at no cost and in an accessible location with transportation assistance available if necessary. It requires the state to reimburse costs for costs associated with providing substance use disorder evaluations within 7 days and at no cost to indigent defendants. It converts the law enforcement assisted diversion program in statute from a pilot project to a grant program, and it removes geographical restrictions on that program. It clarifies the definition of opioid treatment programs. It requires the court that when appointing counsel for a child's parent or guardian who's affected by SUD or mental health disorders to appoint counsel with understanding of the Indian Child Welfare Act and knowledge about tribal welfare systems if appropriate. It requires the Department of Children, Youth, and Families to promote the training for parents of children with SUD to caregivers, including any tribally licensed foster parents and tribal caregivers. It directs the healthcare authority to create a payment structure for health and engagement hubs rather than licensure standards as was in the underlying substitute. It modifies language relating to the mission and permitted affiliations of health engagement hubs, and it removes a requirement directing the Department of Health to invite stakeholders from a diverse geographic region to the rulemaking process. It transfers responsibility for providing a statewide directory of recovery services from the Department of Health to the Healthcare Authority. It appropriates $3.6 million to the Healthcare Authority for the Washington Association of Sheriffs and Police Chiefs, also known as WASPIC, to administer community grants under the Alternatives and Arrest to Jail program for justice system involved persons with behavioral health needs. It appropriates $2.5 million to the Healthcare Authority for WASPIC to provide ongoing grants to the LEAD program. It eliminates provisions directing the Healthcare Authority to establish a safe supply work group, and it adds an emergency clause for affected sections. The next amendment is a page and line amendment to that proposed substitute. This amendment is C1, offered by Senator Wagoner. This amendment does a variety of things. It removes the encouragement for law enforcement to divert simple possession cases to available treatment. It reinstates current statutory language that giving or permitting drug paraphernalia is a Class 1 civil infraction. It removes the state preemption of the entire field of drug paraphernalia regulation within the boundaries of the state. It requires a prosecutor agreement for an individual charged with simple possession to enter pretrial diversion. It provides required sentencing and probation for individuals convicted of possession. It requires the court in simple possession cases to sentence individuals to no less than 45 days in jail if the individual will not comply with the SUD treatment. It requires the court to suspend the entirety of an individual sentence in simple possession cases if the individual agrees to comply with SUD treatment. It requires the court, for individuals who agree to treatment as a condition of probation, to reinstate no less than 45 days of the individual's suspended sentence if the individual demonstrates a consistent failure to comply or willfully abandons treatment. It requires the court to vacate simple possession convictions for individuals who successfully complete a treatment as a condition of probation as required by this act. It removes the requirement that the comprehensive plan of each county and city include a process for identifying and citing harm reduction programs. It removes the availability of housing vouchers to hold bed space for individuals who have returned to use and need a place to stay while negotiating a return to stable housing. It precludes health engagement hubs from providing harm reduction services and supplies. It increases the appropriation provided for alternatives in arrest to jail programs under WASPIC from $900,000 per fiscal year to $7 million per fiscal year from the State General Fund. It requires the Washington State Patrol Bureau of Forensic Laboratory Services to complete necessary drug analysis related to charges of possession within 45 days of receipt of the request for analysis, and appropriates funding to the State Patrol to do so. The next amendment is amendment,
Senator Dhingra, do you have questions on that amendment?
Yeah, I have 3, if I may ask those, and I have lots more, but I'll just pick the top 3.
Go.
And there's a lot of policy stuff in here, so I want to make sure policy staff is prepared for this. So I noticed the 45 days where the Tox Lab is required to complete their analysis. I don't see anywhere where there's a remedy of what is going to happen if they don't comply within 45 days. And am I correct in assuming that that is then the court's inherent authority to either dismiss the charges or hold the Tox Lab in contempt?
And thank you for the question, Senator. For the record, Joe McKittrick's staff counsel to the Law and Justice Committee. The proposed amendment C1 does not provide for a remedy if the Tox Lab does not complete those analyses within 45 days. So I believe your assessment is correct that the remedies available to the court would either be to hold the Tox Lab in contempt or potentially to dismiss the underlying charges in the criminal case.
Thank you. The second question I have is related to the mandatory sanction that the court can impose for violation of a court order. Normally, statutorily, given a separation of powers, we can set mandatory minimum sentences. However, what is contemplated in the bill is actually directing the court to impose a sentence based on a violation of conditions of release or conditions of sentencing. Has that ever been done in our criminal statutes? And is there a separation of powers concerns with this statutory framework?
Senator, I'm not aware of this type of probation scheme ever being enacted in Washington previously. As to the question of separation of powers, I have also found no case law directly on point determining whether or the line between the separation of powers between the judicial branch and the legislative branch. There is analogous case law related to legislation requiring prosecutors to file special enhancements on cases. And in that line of cases, the Washington State Supreme Court found that the issue comes down to whether or not the statute can be read as mandatory or directory. If the statute simply directs, in this case, it would be the prosecutors to file particular special allegations, then it would pass muster under separation of powers. However, if it was a mandatory statute, that would violate the separation of powers. However, that being said, the Supreme Court does presume that, or take the stance that the legislature intends to enact constitutional statutes and will read those statutes to imply constitutionality if that is possible.
There's a follow-up. I can wait for my third question.
Senator Mullet.
Thank you, Joe. I was just trying to, like in a DUI case, aren't people, I know this is different, I think, in Senator Wagner's amendment, but in a DUI case, don't people have mandatory time they have to, on their sentencing, or how does that work?
Thank you for the question, Senator. In DUI cases, there's mandatory sentencing. So, for instance, on a first DUI, the statutes require a sentence of either 1 or 2 days, depending on the alcohol concentration in the person's blood. However, the difference between that DUI scenario and the scheme contemplated in this amendment is this would be a post-conviction sanction rather than a mandatory sentence. I hope that answers your question.
Thumbs up on that. Senator Dhingra, you have a third one?
Yes, my third question. The statutory scheme and the manner in which the court is directed to do certain things is extremely different than what has been done in our other cases. And what really concerns me is where it says that the diagnostic evaluation treatment recommendation shall be prepared under the direction of the court. And as we all know, that our federal law is very clear that any unlawful user of or addicted to any controlled substance uses their Second Amendment rights. So if the court is directing this evaluation and recommendation, I don't see any provision here where the court informs the defendant that they will jeopardize the Second Amendment right if they are found to be an unlawful user or addicted to any controlled substance. Is there any notice of Second Amendment rights being removed or placed in jeopardy?
Senator, the amendment does not particularly contemplate that issue. There's no language explicitly directing the courts to inform any individual of effects of firearm rights. But I believe you are correct that under 18 U.S.C. Section 992, that it's unlawful for any person who is addicted to, or who is an unlawful user or addicted to any controlled substance to possess firearms.
And so when we brief all the other amendments, can you please flag for us all those amendments that would impact a defendant's Second Amendment right, please?
And Senator, I believe that any of the amendments that require a substance use evaluation to be filed with the court, if that substance use evaluation does come back that the person is addicted to unlawful substances, then that would have those same effects on their federal firearm rights.
Thank you, Joe.
Or their firearm rights under federal law.
Thank you. Are there any other questions on this amendment before we move on? We're on C1. Okay, let's go on to C2.
The next amendment is C2 in your packets, offered by Senator Hasegawa. This amendment reduces the crime of knowing possession of a controlled or a counterfeit substance from a gross misdemeanor to a simple misdemeanor. The next amendment is C3, offered by Senator Mullet. This amendment requires the Washington State Patrol to complete testing of drugs in possession cases within 45 days of receipt. It provides required sentencing and probation for individuals convicted of possession. It requires the court in simple possession cases to sentence individuals to no less than 21 days in jail if the individual will not comply with the substance use disorder treatment as a condition of probation. It requires the court to vacate a conviction of simple possession if the individual completes treatment as a condition of probation. It permits the court related to the individual's first instance of being sentenced under this act to use its discretion in determining the appropriate amount of the individual's suspended sentence to reinstate if the individual demonstrates a consistent failure to comply with or willfully abandons treatment. It requires the court related to an individual's second instance of being sentenced under this act to reinstate 21 days of the individual's suspended sentence if the individual demonstrates a consistent failure to comply with or willfully abandons treatment. It requires the court related to an individual's third instance to reinstate 45 days if the individual demonstrates that consistent failure to comply with or willfully abandons treatment. And then finally, it requires behavioral health service providers who provide treatment to an individual in lieu of referring law enforcement officer booking to the individual to inform the referring law enforcement agency if the individual violates the terms of treatment, and in such cases permits the officer to refer the original charge to the prosecutor.
Senator Billig has a question.
Thank you, Madam Vice Chair. Can you define willfully? Is that just dropping out of the treatment, or is it, what's willfully?
And thank you for the question, Senator. The term willfully abandons treatment is not defined in the statute, so that would be a question that would need to be litigated if this was enacted.
Thank you.
Senator Dhingra.
And I apologize, I read these amendments last night. I feel that one of the amendments actually required a fee to be, or a fine to be imposed on a behavioral health agency that maybe wasn't reporting back to the court as directed. Is that in this amendment?
It is, Senator. That's the new section 10 of the amendment, subsection 5 on page 3, line 36.
And do we have any information on any potential challenges that courts currently have in trying to contract with service providers and how that's going?
Senator, I don't have specific information directly in front of me. Kevin Black may have more information on this, but I do believe anecdotally it depends on the many factors, including the location of the court, the availability of local treatment providers. But I do believe that that can be an issue, yes.
And then in addition to the fee, it actually says that their license may be revoked by Department of Health. Is that accurate? Am I reading that right?
That is correct.
And so do we have any information on what treatment agencies might be willing to service this population given these limitations?
Senator Dhingra, we feel like you're litigating right now.
Oh, sorry. Well, I'm a litigator, but yeah. Thank you. I think I've made my point.
You mean you think you've had your questions answered?
Waiting for answers.
All right, I think that answers questions on Amendment C3. Let's move on to amendments. Oh, sure, Senator Mullet.
Thank you, Madam Vice Chair. I think I'll try to speak because these two amendments are identical. The change in this one, I have two amendments here. This one is judicial discretion on the first offense. The second offense has the 21 days. And in the amendment we'll hear next, it has 21 days on the first offense and then 30 days on the second offense. And I think the crime lab turnaround time, our understanding from the State Patrol is with funding, I think it was roughly $3 million. They could get that 45-day turnaround time by January of 25. And I think the goal, I think to Senator Dhingra's last point, was we just wanted to highlight that if this is part of to avoid having to serve time in jail, you run a treatment facility, we just want to know if people leave the treatment facility. So we're just asking for reporting from the providers if somebody decides that for whatever reason they're leaving treatment before it's finished.
Thank you. I'm now lost. Did you brief C4?
I have not briefed C4 yet.
Okay, please proceed then.
Okay, the next amendment is C4, also offered by Senator Mullet. This amendment is the same as the previously briefed amendment C3, except it requires the court to reinstate 21 days of the individual's suspended sentence for a first instance of failure and 30 days for a second instance. The next amendment is C5. This is offered by Senator Wagoner. This amendment removes the state preemption of drug paraphernalia regulation within the boundaries of the state. Amendment C6 is also offered by Senator Wagoner. It removes the sections that add treatment programs to the list of essential public facilities It places limits on reasonable conditional use requirements and removes the requirement for the Department of Health to hold a public hearing related to treatment program licensing. Amendment C7 is offered by Senator Wilson. It prohibits a health engagement hub from providing supervised injection services. Amendment C8 is the final amendment. It is offered by Senator Hasegawa. It expires provisions creating criminal penalties for possession of a controlled substance, counterfeit substance, legend drug, or cannabis on July 1st of 2028, and it directs the Joint Legislative Audit and Review Committee to review the effectiveness of this act in reducing the harmful consequences of criminal justice system involvement for persons who use drugs and its effectiveness at reducing the harm to public health caused by substance use disorders by December 1st of 2027.
Two things. One, have you had time to contemplate whether the fiscal impact of any of these amendments?
I think sort of the clear fiscal impact of a few of the amendments that do provide additional appropriations is documented in the effect statement of those amendments that do provide additional appropriations. The Senator Robinson proposed substitute provides 2 additional appropriations for alternatives to arrest and jail and lead programs. The Senator Wagoner amendment increases those appropriations for the alternative and arrest and jail programs, and the Senator Mullet amendments provide an appropriation to the Washington State Patrol to turn around criminal evidence within 45 days.
And then could you walk us through sort of how these act together? Like if we adopt one, what happens to the other amendments?
Yeah, I'll go ahead and do that, and maybe Joe can be on deck to keep me honest. I believe the first amendment, C1, offered by Senator Wagoner, the first Senator Mullet amendment, C3, and the second Senator Mullet amendment, C4, one of those would, or you couldn't do all 3 of those. You would have to pick one of C1, C3, and C4. Amendment C5, offered by Senator Wagoner, is contained in Senator Wagoner's C1 amendment, so that it wouldn't be necessary to move C5 if C1 moved, and everything else would be able to be enrolled.
Thank you. Any additional questions before we move to the next bill? You got through that one. Let me move and then we can. Madam Chair, I move proposed second substitute Senate Bill 5536 concerning controlled substances, counterfeit substances, and legend drug possession and treatment with a due pass recommendation to the Rules Committee.
Before we move amendments, I'd like to ask folks who are planning to withdraw them. Senator Mullet?
Thank you, Madam Chair. I would like to withdraw Amendment C4.
This will just help make the motions easier. Are there any other withdrawals? Okay. Madam Vice Chair.
I move amendment C.1 by Senator Wagoner.
Is there any discussion? Senator Wagner.
Thank you, Madam Chair. And I think Corbin briefed it as this does various things. That's an understatement. And I do appreciate Senator Dhingra's questions because it would help me to understand ways to improve this amendment. Particularly thrilled to hear about your interest in Second Amendment rights. Thank you for that. So the proposed substitute does some really nice things, but I think the underlying bill is high on aspirations and a little bit low on accountability. And that's what I was trying to bring with this amendment. And the amendment is a result of what we heard from law enforcement in the communities that have to deal with this. And they're the ones that are in the field. So I wanted to be their voice in the form of this amendment to help them to enact the policies that we're placing upon them in the bill. So it echoes the concerns of our mayors and our county commissioners and law enforcement as I've heard them. I guess we can argue about some of the words, whether meaningfully engaged or failure to comply is the right language, but there needs to be leverage to make people get the help that they need. And I think that the amendment provides some teeth. On the floor, we heard about the need to have teeth in a bill about recess. So I think if we have to have teeth in a bill about kindergartners getting recess, we certainly ought to have teeth in a bill that is hurting our communities. And I commend the amendment to you.
Thank you, Senator Wagner. I'm asking for a no vote on this amendment. I think some of the concerns will be picked up in an amendment offered by Senator Mullet further down the line. But point taken, and this is a substitute that will continue to be worked throughout the process. All those in favor of the motion, please say aye. Aye. Opposed? No. The motion does not pass. Next amendment.
Madam Chair, I move Amendment C2 by Senator Hasegawa.
Is there any discussion? Senator Hasegawa?
Thank you, Madam Chair. So I know I am no expert in this subject matter and not on the Law and Justice Committee, so this hit my radar later in the game for deeper scrutiny. So I tried to think about this as a behavioral health, mental health issue. And in doing that, looking at what is going to motivate a person who is addicted or suffering from behavioral health or mental health issues to seek treatment. So there turns out there's not a whole lot of data on that. And so went to try and get some expert input, and who confirmed there's not a whole lot of data on that. But the key is that whatever happens has to happen very quickly, and that is at the time of arrest, and that we have to make sure that there's adequate resources for that treatment to be successful. So they said the level of the offense was not a driver in that decision at all. So looking down the road between the difference of simple misdemeanor versus gross demeanor really has no effect on the front side getting that person into treatment, but could have an effect on the back end where that person, after successful completion of treatment, may have a much more difficult time reintegrating back into a productive work life. So for that reason, I think since there's no science discriminating between whether we should have a gross demeanor or a simple misdemeanor, but what the detrimental effects of the higher level of crime, I think it's safer to go into this at the lower level, and then let's take a look at it down the road. But that's why I'm offering this amendment, is to try and avoid those detrimental effects that could happen afterwards. Thank you, Madam Chair.
Senator Hasegawa, thank you for your comments. I think you are striking at the core of the debate around this bill. And I'm asking for a no on this amendment, as it would substantially change the contents of the bill as they've been negotiated through the process. So is there any further discussion? All those in favor of the motion to adopt Amendment C2, please say aye. Aye. Opposed? No. The motion fails. The amendment is not adopted.
Madam Chair, I move Amendment C.3 by Senator Mullet.
Is there any discussion? Seeing no discussion, all those in favor of the motion, please say aye.
Aye.
Opposed? No. The motion carries. The amendment is adopted. Amendment C4 has been withdrawn. Madam Vice Chair?
Madam Chair, I move Amendment C.5 by Senator Wagoner.
Is there any discussion of the motion?
Madam Chair, I'm recommending that we accept this amendment.
Is there any further discussion? All those in favor of the motion, please say aye. Aye. Opposed? The motion carries. The amendment is adopted.
I move Amendment C.6 by Senator Wagoner.
Is
Madam
there,
Chair,
is there any discussion? Senator Wagner.
I withdraw C6.
C6 has been withdrawn.
Madam Chair, I move Amendment C.7 by Senator Wilson.
Is there any discussion?
Yes, Madam Chair. I think this is a good amendment that I don't think that we want safe injection sites in this particular area, in these health engagement hubs. I think keeping that part away from the hubs doesn't incentivize the drug user to get help that they deserve, that they need to get help to fight their addiction. So I'm hoping that we don't have those in the hubs. Thank you.
Any further discussion? Senator Robinson.
Thank you, Madam Chair. In other parts of the bill, I have specifically, language specifically says that, what's the word? Harm reduction does not include safe injection sites. I'm asking for a no on this amendment today, but I will look at the language of the bill to see if that, as I've described, harm reduction to not include safe injection sites carries for the health hubs. So I will commit to looking at that language, but asking for a no today.
Okay, any further discussion? All those in favor of the motion by Senator, the amendment by Senator Wilson, please say aye. Aye. Opposed? No. The motion fails. The amendment is not adopted.
Madam Chair, I move Amendment C.8 by Senator Hasegawa.
Is there any discussion? Senator Hasegawa.
Thank you, Madam Chair. I guess looking at my amendment, it's unfortunate that it lists Section 9 ahead of Section, or 29 ahead of Section 30, because I think if they had been reversed, it would be more obvious why I'm offering that we expire this thing in 2028. Because there's so little science around this, or data, I should say, around the impacts of what we're trying to accomplish here by recriminalizing simple possession, and the nature of those who are going to be charged with this crime being that they're mental health or behavioral health, oftentimes, not always, suffering from these conditions. There's no data. And I think back to when we were first dealing with the police use of deadly force thing, and we're trying to get our arms around this as an issue and a problem that we might be able to quantify what the problem is, but there was no data back then either, so we had to pass a data collection bill to collect data around the police use of deadly force before we could take action on it. I think this is the same thing. I think that this bill, we're trying to fish around for a solution, but there's no data to support the decisions that we're making. And when we jump to an immediately higher criminal level, we don't know what the impacts of that is going to be, as opposed gross misdemeanor versus simple misdemeanor, or even considering a felony down the road, whatever. So I think it's important that JLARC do a study on this issue, because JLARC has implemented a new racial equity tool that they're going to be looking at our state programs to see, are there disparate impacts, and what are those impacts? And I believe that a lot of these impacts are the result of this so-called war on drugs that has had disparate impacts over the years, and which we're trying to make adjustments for right now. So with the JLARC study, I think it's really critical that we gather that data so that we can look at this problem again down the road, which is why I expire this in 2028 so that we can have that data and make another decision, which we did when we passed the original Blake bill last year, whenever it was. So I'm asking for your support on this so we can make an informed decision down the road. Thank you, Madam Chair.
Senator Wagner?
Thank you, Madam Chair. Well, I'll be voting against the amendment, but only because it has two effects. I think that the second effect, a JLARC study, actually makes a lot of sense. I am wary of the first effect because what if it's wildly successful and we can see that and then we automatically expire it on a date that seems a little bit arbitrary to me. So I'd like to see a JLARC study on it sometime, but not in the form of this amendment.
Okay, thank you. Any further discussion? All those in favor of the motion to move Amendment C8 by Senator Hasegawa, please say aye. Aye. Opposed? No. The motion fails. The amendment is not adopted.
Madam Chair, I move that the adopted amendments be rolled into proposed second substitute Senate Bill 5536 and that second substitute Senate Bill 5536 receive a due pass recommendation to the Rules Committee.
Is there any discussion? Senator Braun?
Well, thank you, Madam Chair. Just a few comments. I think I'm not telling anyone they don't know already. This is certainly one of the top issues we have to deal with this session. It's a very complex issue. I think we could all agree that our state is in crisis when it comes to addiction and the many problems that go with that. I think there's broad agreement that we have to do more to help folks break that cycle. It's not just about law enforcement, it's about services. It's about getting people in services and keeping them in services. We know that the current situation isn't working. We often have very different ideas about how to fix that system, and that's to be expected. That's the way our process works. But we can't retreat into our ideological corners. I don't think we are. I want to particularly thank Senator Robinson for being open to working on this bill. Also, Senator Wagner on our side, Senator Mullet, Senator Gildon have all been active in understanding this complex issue, helping all of us understand better. We have a ways to go yet. We're not quite perfected, but I think we're making good progress, and I think we can trust the system, the process, to get us where we need to be on the floor. So while I think there will be a split vote on our side, I am confident we'll get votes to get it out and have more debate and trying to fine-tune this thing for action on the floor. Thank you very much, Madam Chair.
Thank you, Senator Braun. Senator Robinson.
Thank you, Madam Chair. Thank you, Senator Braun. I appreciate the partnership and the work on this really challenging issue. There's nothing that's going to be perfect in this space, and we are trying to find what will work the best for our communities. And I commit to everyone that we will continue to work on this until we get a bill to the finish line. Thank you.
Thank you. Senator Dhingra?
Thank you, Chair Rolfes. I'll just say I've actually really appreciated Senator Braun even coming to the SURSAC committee meetings for the last year and a half, and there were some of the more challenging committee meetings that I have attended because of the nature of the discussion and the passions that people in that committee had. And I truly do want to thank every participant in the SURSAC committee for the work that they put in. I would have been very excited to support Senator Robinson's bill that was referred to this committee because it can actually work. You can have it running and there will be no issues with it. I always like to be practical, and unfortunately, the bill that we have before us, it just sets us up for future problems. And I'm just going to go over 3 of the reasons why I have such concerns about voting for this bill. One of them starts off with the 45 days for our tox lab. This is setting up the true blood situation we have with the competency forensic evaluations. We are setting ourselves up to either be held in contempt or have dismissal of cases, because those are the 2 options available to the courts when they fail to meet the 45-day. And I just don't think that we need to set ourselves up for that kind of catastrophe. The second issue that I think is extremely concerning is the mandating of minimum days at the point of a condition of sentence. So this is not a mandatory minimum sentence like we do in standard statutory construction. This is, I have great concerns about the separation of power issues, but I'll let the courts chime in on that. The biggest issue with that mandatory 21 days or whatever that time may be is actually a problem that Senator Gildon had identified with what's going on with graduated reentry and DOC. And I've really appreciated that he reads the overdose fatality reports, because what we have found, and of course we have data on this, is that when individuals are released from custody without treatment, the chances of them ODing is very high. And what we are setting ourselves up is actually to see more overdose deaths, because people have to be mandated into custody and then released without treatment. And we have data on that. We know that's going to happen if we do the 21 days mandatory time on there. The third thing, is actually a loophole in our gun laws that this bill is closing. Given that the evaluation and treatment is going to be prepared under the direction of the court now actually has the ability to make sure that we are addressing federal gun rights through the system. Unfortunately, this doesn't have the notice provision, but I'm happy to work on an amendment for the floor. And so we will have to make sure that the court is notifying individuals at the time that they're ordering the substance use disorder evaluation that if they're found to be an unlawful user or addicted to any controlled substance, that they will be losing their federal Second Amendment rights. And then we do have to make sure that we have processes in place that notify them of the ineligibility to possess a firearm and do the surrender forms. But we have cross-references to that. So that is a part that's missing, but I am actually glad to see that we are closing this very large loophole in our gun laws. But even with that amendment, that part that I do like, I will be a no. Thank you.
Thank you. Senator Wilson.
Thank you, Madam Chair. I just wanted to kind of underscore some of the recent data that we have received concerning overdoses. I think we need to remember, Senator Dhingra just mentioned some of that, but right now in Clark County, we have babies and little kids that are overdosing on fentanyl because this has become such a huge problem. 25 babies and kids overdosed in Clark County in 2021, and in 2022 it nearly doubled. So this is something that I just can't even fathom. And the drug overdose deaths in King County since Blake decision has occurred have tripled. It tripled over per week. And so I think, and the other thing to remind ourselves is that anyone under 60, the number one cause of death is drug overdoses. So I appreciate that we're working forward and trying to come up with an answer. So I appreciate what we're doing today. Thank you.
Thank you. Before taking the vote, I want to say how proud I am of the deliberative work that the members of this committee have been doing. The sheer number of senators on this committee kind of ensures that we have a pretty broad representation of the Senate. There's a lot of different opinions on this. There's something that everybody doesn't like in the bill that's going forward. And I want to add my thanks to folks for working across the aisle and with people with different ideologies to keep trying to get something that we can move that will save the lives of small children and people in our communities and our friends and neighbors. And so I would just want to say thank you to everybody who has worked on this, which I'm guessing is about half of this committee. Is there any other discussion? Seeing none, all those in, did you make your final motion? Yes. All those in favor of the motion, please say aye. Aye. Opposed? The motion carries. With your votes, you have moved proposed second substitute Senate Bill 5536 to the Rules Committee, subject to signatures.